Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell, Donawa, attorney at law. Once again, I'm happy to be alive. I'm happy to bring the law and you. Of course, you can stream us on the traditional media as well as our social media, WESN CC on all our platforms. Especially, you can also listen to us at Strictly Legal with RondellDonawa.com. The last week, of course, you would have been very, very excited actually to view one episode about medical malpractice with Mr. Otway, who is an attorney at law, and he's very experienced in the field of medical legal practices. And of course, last week we recapped basically about what is medical negligence, what are the consequences of such negligence, what are the tests, right, that one uses to establish whether a doctor or hospital has been liable for such negligence, as well as some of the damages. Of course, time was obviously beyond us, and we had to now bring him back for another episode, or for part 2 of the legal implications of medical malpractice. And Mr. Otway is no stranger to the field, and of course I will welcome him back. Robin, good day. How are you?
Fine, thanks. Great to be here, Rondell. Enjoy the exercise.
And great to have you as well. I know, as you said, it's very hot in Mexico at the moment.
It is where I am. Northeast Mexico, temperatures get up high 40s.
Wow.
48. It's not unusual. Sometimes at night, 10 o'clock, it's like 32, 33.
Well, at least we could be grateful at least for our humid weather here. But
it's dry.
Oh,
Semi-desert. Wow.
Yes.
Yeah.
But nonetheless, thank you for making the effort to sit with us again. Just a recap in terms of medical negligence. Could you just bring out just a recap in terms of the definition of what is negligence?
As I defined it early last week, a doctor is required to practice up to the standard expected of a reasonably competent practitioner in the particular field. And I gave examples of the GP and the obstetrician gynecologist. And that in any procedure recommended, which could include taking particular pharmaceuticals, drugs is a bad word these days, therapy, surgery in particular, the practice that is, the procedure that is recommended must be one that is approved by a responsible body of medical opinion. Those are the two basic tests.
And of course, we've delved quite extensively into exactly, as you said, the tests and various examples. But of course, we want to touch on, we want to continue the discussion. More importantly, the question of a doctor who has performed a surgery or surgical procedure, whatever it may be, on a patient, whether it is in private or a public health facility, and something happened to that patient, whether they has now become disabled or they had died. Who exactly is responsible?
Okay, that is a particular, as a good cook, something special or specific about medical negligence. A simple example, agency is where in everyday life, for example, a real estate agent, I'm going to compare a real estate agent with a building contractor. The real estate agent acts how I instruct him. I may tell him a particular price for my house. He may come back with a lower price, but he has no authority to accept it unless I tell him to accept. The building contractor, you don't tell him how to build a foundation or install the electrics and plumbing, etc. He uses his independent and expert decision-making, independent expert mind. Now, the doctor, particularly the surgeon, nobody tells him wherever he's employed, whether it's government hospital or in a private institution. The doctor, surgeon, exercises his own professional judgment. But the precedents, the cases decided that where the doctor, for example, in a public health institution, in a government hospital, the patient does not choose the doctor. So the institution is relied upon to ensure that a reasonably competent surgeon is practicing within its four walls. So within a government hospital, the surgeon or other doctor, whoever be a nurse or anyone makes a mistake that affects a patient, the government hospital is individually liable. Normally, if you're bringing an action like that, you bring it against the hospital and the doctor. That's in normal practice. Everybody who could be liable. Now, with the private clinic, it's different. It is normally different where surgery is involved.
No, just pause a bit. Sorry about that. So you're saying that in public institutions, the hospital is the one that will be the liable party, basically.
The hospital is liable for the doctor's mistakes, but he is also individually liable.
Certainly. And now we are getting into private institution where as you said, it may differ.
Yes. Okay. Now, in the private institution, normally if I'm going for an operation, I have chosen my doctor. I want a particular doctor. I'm paying good money, so I choose. I want the surgeon of my choice to operate upon me. And surgeons will operate at different private institutions where they have what they call privileges, the right to use their facilities. They have an arrangement, let's say, with Sinclair or West Shore or Medical Associates or wheresoever. So if I choose my doctor and my doctor makes a mistake, my doctor is responsible for his mistake, not the private institution who did not choose the doctor. Now, I may go into a private institution in an emergency where an accident and emergency doctor whom I have not chosen, but is put there by the private institution, he makes a mistake, then the clinic is like a government hospital. The private institution is responsible for the doctor they have chosen and who happens to treat me in a situation like that. Hope that's clear enough.
So is it that if, as you said, if I choose a doctor and the doctor has elected, or let's say the doctor is whether it's an independent consultant at a particular private institution, the doctor is held liable. However, if I let's say I retained the institution itself to perform the surgery, then the institution is liable.
If the institution is the one that has put the doctor in place to carry out the procedure.
Okay.
Right. Supposed to be choosing my doctor to do the operation upon me in a private setting, not a government hospital. When I go into the government hospital, I take whatever doctor is on duty who will perform the surgery upon me. I may be lucky enough to get a doctor I like, but I haven't chosen the doctor.
But then let's say you choose the doctor and it is not the doctor's fault, but it's the facility. Let's say there has been some defective equipment, because obviously the doctor is just there to use his skills, which is his hand. Yeah. But in terms of the equipment,
it's not always the doctor's fault. Sometimes there may be, sometimes it could be a nurse making an error in terms of when medicine is administered. Post-surgery, it can happen. The clinic, private institution may not have certain equipment or may not use the equipment when they should have used it. Okay, so the clinic will exercise its own judgment, particularly with post-operative care. After an operation, the nurses have to monitor, they have to check vital signs, blood pressure, breathing, etc., pulse. And if they don't do that properly, then they could be liable.
I totally get you. So in terms of investigation, let's say, for instance, you are now to investigate that particular, who is liable. How can one proceed to that investigation? Is it that you now have to retain an expert, as we will now get into?
I gave examples the last time of what may be obvious. For example, I go in to have my right leg amputated or below the knee amputation on the right, and they do it on the left. Okay, that's obvious. You don't need an expert to say the doctor should not have done this. I gave another example of what I call the retained object, where something is left inside a patient during the surgery. You know, there are pads put in. There are cases when even metal objects have been left in, which of course is obvious. It may not manifest until sometime after, but the surgeon cannot get away. It's his responsibility to ensure that the objects inserted, put into the patient's body are removed. He will have a nurse normally who will count and the highest form of practice, there's a blackboard and they note the things that go in and they make sure they come out. But the surgeon is responsible if that is not properly done. The clinic could also be institution could also be responsible. Should be. But where the medical legal area, I would describe as very complex. So in the normal medical legal case you're suing your doctor or clinic or hospital, you will need an expert input because it's not always black and white. You know, a patient may die on an operating table, but it may be that they had some problem with their heart or something. I mean, before a patient goes in for an operation, both the surgeon and the anesthetist must take a proper history. But if the patient doesn't say, look, or the patient will be unaware they have a heart issue, and you die on the operating table, sadly. So you need an expert to review all the medical records. You will give him the history, the client's statement, and you want an expert opinion because the case will normally stand or fall. You may be successful or not at the end of the trial based on expert evidence.
And of course, that expert evidence, as we would have discussed, it's obviously, as you would say, expert is someone who is familiar or who has particular experience in that area of medical practice.
A doctor.
Yes, a doctor, basically. No, I note that, and I would have also stated that, you know, sometimes, at least in Trinidad, there's a perception that medical practitioners, particularly doctors, they pick up for one another, right? So in terms of getting that particular medical expert to testify against another institution or doctor, because I mean most times you find that doctors, whether in their private practices, they would interchange in terms of the facilities that they practice in. So how do you circumvent or how do you avoid having such an issue where doctors are not cooperating rather?
Yes, I mean, it is a problem. I would not deny that. Now, it is not that you cannot find doctors within Trinidad and Tobago who are prepared to testify against other doctors. It may be common with someone who may say is retired, but there is that kind of, if I may call it brotherhood or sisterhood, a collegiality. They are afraid of getting blackballed within the medical profession. You know, their colleagues don't like them anymore, don't trust them. And often they know each other well. So not always, but let me say that I have seen Trinidad doctors testify against Trinidad doctors. It's rare. In complicated cases, you normally look for an expert outside of Trinidad and Tobago. I have spoken to a doctor in Barbados who is willing to help. But from my experience, the norm is you look to the United Kingdom, you look to Britain, where you will find many experts. There are actually companies there. I know of one called Foresight, which provides medical expertise. They have like a panel of doctors, and you want an area, let's say, of obstetrics, gynecology, they will have an expert gynecology. And these are normally semi-retired or retired doctors who frequently testify in court. So they will offer their services, but it comes at a price.
Yes, and that price can be very, it can be very high, basically.
Yes, the first step, the recommended first step, and the really wise thing to do, the prudent thing to do, safe, is to get an opinion from an expert where the case has some complexity before you file the action, because you may file an action and later regret it. So the first step is to request a written opinion. You want it in writing. And a written opinion in a recent case of about 2 years ago from the United Kingdom cost from an experienced doctor who has both experience in medical practice and in testifying. And that's a particular area. You want a doctor who can testify, who's articulate, who can withstand cross-examination, etc. But an opinion from such a doctor costs £3,500. You get an opinion, you cannot tell the doctor to give you the opinion you want. So the opinion may be unfavorable to the case.
And I mean, but obviously that would now basically build or form a parameter as whether or not your case is strong and whether or not you should move forward, rather than going in with a blindfold and you end up spending more monies by virtue of having to pay your legal team plus cost to the other side, and if you fail in your bid, in your litigation bid.
Now, I have taken the chance, over the years, I've got to know doctors, I've defended doctors, I've sued doctors. But in a case where I was bringing an action against a doctor, I called a friend in the particular, a doctor friend, experienced doctor, in the particular field, and he said, look, boy, I'm not going to testify against this doctor because we work together all the time. So I said, look, meet me for a Chinese meal and I'll get some information from you. And so we were eating Chinese food and I was writing down his points. I took the chance there because it may be that when we got the expert opinion from the doctor who was prepared to testify, he may not agree with my doctor, my friend. But that is risky.
Indeed it is. But in terms of the expert, obviously you are now before the court, and then you have attorneys questioning you based on certain evidence or certain exhibits that were provided. Now, in terms of the attorney or their line of questioning, obviously an attorney is an attorney who has knowledge and experience in law, and then a doctor is a doctor who has his experience in medical field. How does the attorney get the proper evidence out from a medical practitioner if that attorney basically does not really understand the medical terminologies, etc., or medicine on a whole?
He or she will have to make sure that they do understand in a particular area. And of course, the defense, the lawyers representing the doctors or the hospital, will get their own expert advice. I think it would be reckless to be cross-examining a doctor in a complex area of medical legal, and you don't have an idea, a good idea or good understanding of the particular area of practice the case involves. So you have to get your advice from your side's own experts and prepare your cross-examination of the doctor accordingly. Cross-examination can be a rough thing. It can make big men cry. I haven't seen it happen in a medical legal case, but doctors testifying for one side are put under considerable pressure. And that's where the ability of the doctor to stand strong and to articulately or clearly put across his side of the story to be able to respond to the questions. Because not all doctors, a doctor may be an excellent doctor, but he's not very comfortable going to testify and take cross-examination. Some doctors I found, particularly surgeons, can be quite tight-lipped. The joke I give them is that you don't like people talking to you. You like me to be out cool on the operating table and you just do your work. So not all doctors, as expert and as great a doctor as he or she may be, may make a very good witness. It's totally different. So that's part of the process of assessing whether your expert witness will be able to handle him or herself well in court.
Yep, so it's really not a matter. Yes, the expert is important.
Yes.
But in terms of whether you can articulate those findings properly so that the court can consider. And of course, an expert witness is important for the court, meaning the judge, to consider whether or not to give weight to that piece of evidence, right? So that will allow for a sort of informative decision as to whether the doctor or hospital or both are liable, because both can be liable, not so?
Yes, of course, in the situation I mentioned, as we discussed earlier today.
No, No, if we can, I mean, I know it's in essence you would have discussed in terms of what are the pros of of an expert witness. But in terms of the cons, I mean, I also know that you stated that some may be tight-lipped. But what are the other cons, if there are any, or pros which we have not discussed in terms of using expertise to assist with your case? Because I'm assuming that if you don't use an expert, then your case cannot be assisted.
It may be difficult, a lawyer not calling, let's say I represent a patient and I don't have a medical expert in an area where it's needed. I may be sort of flying by the seat of my pants in the sense that I hope to cross-examine the opposing doctors. And of course, you will cross-examine the doctor who you accuse of negligence. You hope to elicit, you hope to get answers that favor your case. But if you don't, if the doctor stands up well to your cross-examination, doesn't give you the answers you want, well, guess what may happen? You may lose.
You may lose, yes. And is there any way in terms of, and of course, I guess that is really by way of legal aid. And I would have explained a situation whereby, someone who came to me with respect to a particular case, but they weren't able to retain an expert doctor. And obviously that means that that person or cannot really seek justice that they deserve because of lack of funds.
Well, legal aid, I'm no expert on the legal aid authority, but as I only know them to be covering the cost of lawyers. It may well be that they may cover the cost of an expert opinion. I don't know. I can't say.
Yeah.
I can't think of any case. I cannot recall any case where a patient was legally aided in a medical legal setting. I can't recall any case like that. I cannot tell you if they will cover the expert costs.
Indeed. And when we look at, let's say, mediation or getting further into the discussion of mediation, to whether it is to prevent or rather to settle without extensive cost to, well, both parties, I should say, the one who's the litigant who is suing and the one who's being sued. We discussed, yes, the importance of mediation, but I want to get more involved in terms of case examples as to the mediation, the significance, and how mediation in these cases really assists. Particularly in our jurisdiction, mediation in our jurisdiction is something that, yes, it is known, but it is often not really encouraged because of different circumstances. But it should be.
Yes, I have been representing either doctor or hospital or clinic in 3 medical legal mediations. All resulted, no, there were 4. 3 of the 4 resulted in a settlement, so the odds are high. Now, understand that a doctor may have the resources to defend the case, but no doctor likes or looks forward to the idea of being sued, because even if they win, they may feel that they may lose in terms of their reputation. And I can tell you, I have seen big men, very experienced and good doctors, stressing out big time over cases against them. I remember one very experienced and quite well-known doctor crying with the stress of it in my office. So mediation, as I describe the process, and it's something I'm very passionate about. I've been a certified mediator a number of years. I do a bit of teaching in mediation. And my love of mediation came about because of a particular medical case. But what is the beauty of mediation is it, as I tell my clients when I advise them to do it, it allows you to keep the power in your own hands. Mediation is not a process guaranteed to succeed. It's a process that allows a settlement discussion. The mediator is there not to make judgments, but to facilitate a discussion, which hopefully leads to a settlement. It can lead to a win-win or something approaching a win-win where the doctor decides, okay, I will agree to pay less than the amount which is being sought. The patient, mediation, settlement involves give and take. So it allows the parties to sit face to face, which which may be difficult sometimes. Patients or their families may be deeply resentful. There may be even hatred of the doctor who they feel has caused them major problems. A baby born with cerebral palsy, patient dying on the operating table, coming out handicapped. The case that really turned me involved a brain-damaged young man who was essentially, the expression is in a vegetative state. He was 9/10, 8/10 vegetable, very healthy, happy, active young man who played rugby and basketball, went in for an operation, came out brain dead. He had nothing approaching a normal life after that. I was representing the family. We went to mediation. Normally, you saw a doctor and he ends up hating you for life. We came out as friends after getting a settlement that everybody was happy with. It is a case, I tell people that if on my deathbed, which hopefully is not too near at hand, I think of any case, it's that one. That one was hugely satisfying. We came out as friends. It started with a profoundly emotional moment where the three doctors who were sued, it was a case with surgery, each one looked at the brother and mother of the young man who lived his life bedridden thereafter, unable to speak, even after extensive speech therapy, complete sentence properly. It started with each of them looking the mother and brother in the eye and saying, "Madam, sir, I am filled with remorse for what has happened to your son and brother." That was a profound movement for me, brought me close to tears. Maybe I am that way now. But one, it's largely a successful process. I said there were four, no, there were five. Four of the five were settled. I was not the mediator in any of them. I was representing a party. So it is, the odds are high. It saves a lot of costs because going to trial, especially in a medical legal case, is very, very expensive for reasons which I think I've identified at least one of them. So I highly recommend the procedure because when you go to court, you put your case in the hands of the judge. Judges are human. Cases don't always, witnesses may testify well when you speak to them, for example, the medical experts online like this, or with your clients in the office and their witnesses. They may not always do well when they have to stand up for cross-examination. The judge has to make an assessment based on what he or she sees during the period of the trial. And so the judge is the one with the ultimate power to say, yes, you have a good case, or no, your case fails, and you have to pay the doctor compensation for his legal expenses. And that's the worst of all worlds.
Yeah.
Going to mediation early on is highly recommended.
Can you give us, I know you stated that at least 4 out of 5 of the mediation that you would have had conduct of has been was successful, settled, that is. Let's look at the one mediation that was not settled. Can you just, without, of course, disclosing the parties in terms of, yes, in terms of just that example as to why that particular mediation was not successful in settling?
Both doctor, I was representing the patient in that case. Both of them felt strongly at a personal level against each other and took hard positions. My client, I recommended that he soften his position in an effort to avoid the risk, cost, time that it would take to bring a matter to trial. But neither side was prepared to yield, and that can happen. They take fixed positions and they don't yield. Sometimes the mediator is able to, what we call focusing. A mediator will sit privately with one side and then sit privately with the other side right after, because the mediator has to make sure keeping the appearance of neutrality. And sometimes a mediator will work with a witness who takes a hard position. But where both sides are taking a hard position, that's really difficult to deal with, to get that settled. So that's what I would say produced that negative outcome.
And especially it is not, I'm assuming, sorry, it's not legal positions, but medical positions that both sides are taking.
A patient may feel he has a strong case, he's bound to win, and the doctor may feel the same way. And the lawyer that brings the client to mediation can play a very important role in sort of softening that position. I tried hard with my client, but he wasn't willing to move because I felt that if we came up with something different to the figure the proposed settlement sum we started with, it might cause the doctor to soften. Because I would call my colleague aside, the lawyer for the doctor, and say, look, we have given some ground. We started with X and now we've given ground. Please see if you can get your client to do the same. We know why it's great to come out of this with a settlement instead of court.
But then how do we take into account the medical the medical institution? Because I'm certain, let's say for instance, you have to go into mediation with a medical institution such as a public hospital. I don't know if they ever do that. But in terms of, pardon?
I've done both, yeah.
Yes. So in terms of arriving at a settlement, yes, the doctor may have one position, the doctor may concede, but then is whether the institution are willing to compensate, because the institution might very much say, well, whereas, yes, my expert or my medical practitioner is saying X, I believe in Y, because at the end of the day, most likely, it may have to go to the board of directors for the board of directors to approve or not. So sometimes it does not necessarily boil down to the doctor themselves to make a decision. That goes beyond the doctor, even if the doctor has some form of opinion as to liability or damages.
Yeah, I mean, understand both sides will have their experts, should have their expert advisors, and experts will not always agree. You know, the experts on one side may say one thing, that the patient has a bad case, and the experts for the patients may say the opposite. That happens, and you have very capable doctors who are experts and familiar with testifying, who will disagree with each other. Just as lawyers, very experienced lawyers, will disagree with each other on particular cases. In my experience, the institution is normally the least exposed in terms of what they may have to pay, and would normally go with the doctor. If the doctor decides to settle, the institution would normally put in something. The doctor is usually the one with the heavy dollars to deal with. If board approval is necessary, that is something. Mediation does not will normally take 2 sessions. The mediator will tell the parties at the beginning, if you need any approval, you may need a break to get approval from your board, or you may need to call somebody to get approval. All well and good. We can come back another day if you need to go to a board meeting or have a consultation with different people face to face. So mediation has a flexibility that allows for all of that.
Right, correct. And of course, it is more of a softer approach in terms of, in terms of parties meeting at a better setting to be rational or not too adversarial.
Correct. The mediator can assist in sort of bringing down the temperature, deflating or draining off some of the hot air, because there is often very hot air. Tears are shed and horrible things are said, not only in medical legal. Some pretty horrible, sometimes obscene statements can be made, and that's all part of mediation. The mediator will allow a little escape of pressure like a pressure cooker, and then say, okay, let me meet you in focus and let's discuss what you're talking about there to try and bring the temperature down.
In these circumstances, does a mediator have to be an expert in these circumstances, like in this circumstance?
Yeah, mediators, certainly in Trinidad and Tobago, have to be certified. All sorts of people, not just lawyers, human resource, all sorts of people, business, people who have expertise in business can be mediators, loss adjusters. The man I understand to be have the highest numbers in North America, that's Canada and the USA, in mediations with a high level of success is a loss adjuster. He investigates insurance claims, so he's often dealing with claims against insurers, which could involve personal injury claims for accident, car accident. So mediators, they have to be certified. They will not be certified unless they have a certain level of experience and show that they have the sort of raw materials, the communication abilities, and the interest. Of course, you have to apply to be certified. Go through two different courses, and they also give you a test. Okay, so the mediator doesn't come about just so.
Indeed. I mean, of course, I note that mediators has to be qualified because there are services where you are trained and you have to be certified. But in terms of, because medical legal is a very intricate and obviously solid area of law, and my question would have been whether or not that mediator has to have some knowledge of medical negligence matters, etc.
Remember, the mediator is not there to make a judgment. The mediator's fundamental role is to encourage and facilitate a discussion that leads to a settlement. So the mediator is not there to say to one party, maybe privately, you don't have a good case here for such and such a reason. The mediator is there to encourage discussion. The most successful mediator I know, I think that person has limited experience in medical legal. It's her personality and the approach which helps to diffuse the situation, which helps to keep the discussion going. That is key to the mediator's role. When I mediate, I sometimes describe myself as a lightning rod. Take the heat of the lightning of emotion and try and run it to earth and bring people to a place where they can talk.
And also it's important for legal practitioners to not get too emotive when dealing with matters. I mean, because you've seen it, in other matters like family proceedings, particularly where in mediation sometimes it gets very personal.
Yeah. I have never done a family mediation. I don't plan to. I am a product, as I put it, or maybe culpable for divorce. Emotionally, I can't deal with it.
Yes.
So we leave that aside. But family mediation really requires expertise. The family court in Trinidad has mediators on staff, and that's all they do. There are lawyers who practice extensively in family law, divorces, and so on. They are the ones best equipped. But it's not, maybe if I didn't have that experience, I would be able to do it, I hope, reasonably well. I hate to see children suffering, not just because of my experience.
Yeah, I totally understand that point. Now, in terms of medical malpractice, I know that you, what are the areas that are notable that should be discussed in this area?
I think one issue, we start off, as I understand it, what are the patient's rights?
Yes.
Now, when you
informed consent,
you want to sue Dr. X. Dr. X may have seen you a couple of times, carried out an operation, may have a long history with you, so you need his medical records. Because the expert who's to advise you, where you need expert advice, which is, I think, at least 90% of the cases, he needs to understand the full history. Some doctors are not willing to disclose their medical records. The ones I advise, I always say, look, if you're going to hold them back, you're not looking good, and there's a good chance there will be an order of the court made against you that you must disclose. In England, there's actually legislation, an act, a law that says it's called the Access to Medical Records Act. We don't have it in Trinidad. And I have seen doctors refuse to disclose, saying that's their personal property. I don't think it's a wise position to take. I try not to use language stronger than not wise. But a patient should be allowed access, and if the doctor refuses, I have seen cases, not by me, where a preliminary application is made. Another lawyer I'm thinking of who's very experienced in medical legal. Preliminary application was made to force the doctor to disclose, and that was successful. But it cost money.
And of course, we are dealing with doctors in private practice, because I do know that in public institutions, through the Freedom of Information Act, you can request your medical records.
Yeah. The Freedom of Information Act in public institutions, good point.
Yeah.
A private setting is not governed by Freedom of Information Act.
And this is the issue that of course we face, because in terms of access to records, whether it is medical, any type of records, it does not extend to private institutions or private companies, etc. And of course, it means that a patient or a litigant or whoever is aggrieved, because how do you access these records but for an order of the court?
Normally, the doctors will release them. I've only known of one case where the doctor was refusing, which I didn't think was. I was not representing the doctor. I've had doctors ask me when I represent them, should they disclose? And I say, oh, yes, definitely. You're not going to look good if you don't.
And in terms of the consent issue, of course, we would have raised, if it's a minor, then the parent is the one that has to consent.
Yes,
if it's
or person under disability, somebody mentally disabled. For example, that young man in a very sad case, he continued to live, but he needed further procedures, different procedures. The doctors had to come and make house calls, and sometimes he was taken by ambulance for players' blood or whatever. So the person, the guardian, the parent would have to give that consent. Okay?
And if it's a situation, let's say, where there's no next of kin, and obviously one person the patient has gone into a surgery, and the doctors has to make a decision. Who makes that decision in the absence of a next of kin?
Sometimes a doctor may start an operation thinking that, okay, I'm dealing with a gallbladder problem, and may discover something completely unrelated which can kill the patient. Issues with the heart certainly are there, but there was no advanced knowledge of for good reason. So the doctor has that license to carry out procedures that will save life, or to preserve life, or avoid further serious complications. But a patient is brought into the hospital by somebody, and that person is the one that should give consent in the normal run of things. There could be an accident case in the middle of the night and somebody is taken to a hospital and a life-saving procedure. It will be understood that there wasn't a context where somebody could be called or say, could you come to this hospital and give a consent? Because by that time, the patient probably is dead.
Indeed. Ladies and gentlemen, let's take a pin. You're watching Strictly Legal. We have to take a break. We'll be right back. Welcome back. You are watching Strictly Legal with Rondell Donawa on WESN Content Capital. We are speaking with Mr. Robin Otway, attorney at law, who is experienced in the medical legal field of law. And we are speaking about, of course, the medical implications or the legal implications of medical malpractice. Before the break, Mr. Otway and I, we were speaking about mediation and, of course, informed consent. And let's deal with now, Mr. Otway, in terms of a patient's right to a second opinion.
Yes. Well, I am paying my doctor for his services in the private setting, or if I'm seeing a doctor in the public setting, I may decide, and it's my right, of course, it's my money, I may decide to go to another doctor. It may not be that I feel my doctor is, as it were, doing nonsense, making a mistake. For example, if I've been given a diagnosis that I have a condition, terminal condition, I will die in 6 months. Well, the normal reaction is to go for another opinion and hope for the best. But every patient has obviously the right to spend his or her money on getting a second opinion. Sometimes a patient will tell his or her doctor, look, I think I need a second opinion. And that can get the doctor upset. But certainly, if I'm advising a doctor and he or she is upset about a question like that, I would say, look, you need to play it cool. Because getting upset may suggest to the patient, it may look like you're being defensive, that you're not sure. Let your patient go and get this and say, look, yes, go and get the second opinion. I'm not God, as a doctor talking, this is how I would recommend it. Maybe they will give me some insight that I have picked up. They may say or write something useful. One never knows. So,
and then that second opinion sometimes may work in your favor. If it works in your favor, then what happens there? Because it's a bit of a catch-22, because one doctor is giving one opinion that your case may not be successful, but the other is giving a directly opposite opinion. When now it comes to going before the court and you now have a joint expert, if the joint expert now decides to give an opinion that the first doctor opinion was, then what happens there?
Now, joint expert is has a particular meaning in terms of a legal case. Sometimes the parties will agree to have one expert advise the court, as it were. But that is very unusual. I've never seen it happen in medical legal. It'll happen like in a boundary dispute where one neighbor says, "You're encroaching on my land, you pushed your wall 2 feet into my land." And they appoint one surveyor who's well recognized and both parties trust, both sides trust. That surveyor gives his opinion. But in medical legal, you'll hardly get a joint expert because, the parties are daggers drawn, as it were, hostile. But the second opinion, pardon me, could you go back to your question there? I may have gone astray.
Sorry, the connection, there was a little pause.
Okay, I was saying that a joint expert in the context of a legal estate case is a situation where both sides agree.
Agreed, yes, correct.
One expert give an opinion which will guide the courts, right? The judge is not necessarily bound to agree with what the joint expert says. And that's another issue again I can touch on, but at this time.
So therefore, in this situation, you would always have two experts, one for each side.
Context, yeah, you would not be in court. If there's going to be a joint expert, that would be wise to have that earlier clock and avoid all the stress and time expense of litigation. But in medical legal context, you're going to have, in all the cases I know about, I've read about, opposing experts. One expert agreeing with one side and an expert in the same field being of a contrary opinion. All right?
And Mr. Otway, in closing, just give your views in terms of medical malpractice. I do know that, of course, a colleague had a question that I spoke to you off record.
Yeah.
Can we just, because I know this is something which is a prevailing, this was a House of Lords decision. So can you just give us a synopsis as to what exactly was the issue there in terms of the scenario? Of course, I will allow you to give the scenario.
You had a young, very capable, excellent doctor who went in for an operation and came out like in the sad case I told you about. Well, she was comatose and lived in a comatose state, not feeling anything, of course, in a coma, for a couple of years until she died. I think it was years. And the issue there was whether during that period of coma, the doctor was entitled to compensation for pain and suffering. Whether additionally, and to me the more fundamental area, is loss of enjoyment of life. Can a person in a coma be said to lose enjoyment of life? And what the court said is that even if they're not aware of it, they have lost significantly. And they're entitled to be compensated for loss of amenity, and if in a comatose state they're having spasms or whatever, suffering pain, they may not be aware of it, but they are actually suffering pain. So the court awarded damages or compensation.
And of course, that is to deal with there's one particular issue with respect to whether or not they lost, or whether or not they knew that they had lost enjoyment.
Yes.
Even in a chromatic stage.
Yes. They have lost it, whether they're aware of it or not. They have lost it in a very fundamental way, to state the obvious, they have no life. This was a young lady, maybe 32, young for me, and who had a long career ahead of her, was showing every sign of being a huge success, very intelligent, very successful practice. A highly regarded doctor, sadly slipped into a coma during the operation.
No, there's so many different angles and scenarios with respect to cases, because of course medical practice goes beyond, I mean, of course, in the field of medicine itself, there are various areas of medicine, medical practice, right? And of course, each case is different on facts, but the principle sometimes remains the same.
Yeah. Would you like me to quickly recap the rights of the patient?
Yes.
We wrap up?
Yes.
The right to be treated up to the standard of a reasonably competent practitioner in a particular field. Pardon me, I'm just looking at some notes I made briefly. The right to have any practice or procedure recommended or adopted by any doctor accepted as proper by a responsible body of medical opinion. The right to give informed consent to any treatment, including surgery. The right, and this is something I don't think we touched on specifically, to have a full explanation of any medical condition diagnosed by the doctor, the treatment recommended, whether it be drugs, surgery, therapy, and how the course it may take, how it may progress in future. The right to the second opinion. Okay, I think these are the basic recognized rights according to Trinidad and Tobago law.
Indeed. And I'm sure, Robin, the practitioners as well as laymen alike will be very grateful for your legal expertise in disseminating the information that is required. I know you stated that you're in semi-retirement, but of course, you know sometimes one may call you out, yeah, to assist. Right, because you're never too old in this practice.
I have one case right now in medical legal.
Indeed. And thank goodness for the opportunity, or I wouldn't say thank God for COVID, but at least COVID would have propelled or accelerated the use of virtual platforms in terms of whether it is court, in terms of meetings, and also with us having the opportunity to speak, right? You being in Mexico, I am here, and we are very happy that that with your assistance, right, that the viewers and listeners as well are able to fully understand their rights, their responsibility, and of course, in terms of what recourse can they have by virtue of the courts, or as we said, using alternative dispute resolution, which is mediation.
Yes. Or arbitration.
Or arbitration, correct. So
pleasure to be here, Rondell. Thank you.
So thank you so much, Robin Otway. We do appreciate you, and of course, maybe we'll be back next time on a different area of medical malpractice, and and until next time, thank you so much.
And thank you too for your patience.
Guys, it's a wrap. You have been watching Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, attorney at law. Of course, you can stream us once again, WESN CC, and of course, our podcast, Strictly Legal with RondellDonawa.com. Thank you so much for listening and viewing. And of course, I will leave you with this quote: the difference between ordinary and extraordinary is that little extra. Be good, be well, take care.